two flags, two very important flags where we're sitting. Trademarking has a very interesting, cross section in the middle of these two drapeaux. So we're in Quebec. We have to respect language laws in the context of all of this weird common law stuff. So Quebec is a bi-jurisdiction. It's a dual jurisdiction in civil and in common law. So we have federal things that are common law. Anglo provinces are common law. Criminal is common law, meaning it's the same code across the country. And trademarking is common law. So what happens when we bring common law into a civil law jurisdiction? So, as I had indicated to you in the beginning of my blurb, we have companies, big box companies, that do big business in Quebec, that have a lot of pride and have a lot of money vested in their branding. Best Buy, Second Cup, Toys R Us. The list goes on. So how do they deal with these language laws? How come we see stories in the Gazette about a little cupcake store in a little Anglo district of Hudson who gets visited by l'Office de la langue française and who's forced to shut down, and they call the Gazette and they make a big story? How come she has to shut down? And how come Best Buy goes unperturbed and is allowed to make billions of dollars in the province under their English name? It makes no sense. But if we look behind the legality of how they're doing this, is a very simple answer. They are trademarked. Best Buy is trademarked federally with the CIPO. The same way that Mr. Urban and Spirit Bear did it, the same way that Legal Logik did it, the same way that all of you will do it. Best Buy has a trademark and has a heavy trademarking team that goes around making sure that not only are people not using Best Buy to imitate, but that they're protected and that they stay abreast of all changes in the industry. So, Best Buy has deep pockets. They hired an army of people like me, a lot more gray hair and a lot higher offices on a lot higher buildings downtown. And they said, we are going to pay our lawyers a lot of money to fight the government's initiative to force Best Buy to adopt a French version. We're going to go all out. So we're going to give massive retainers to our companies, to our lawyers, go out and fight them. And they did. The lawyers did a very good job. And it made it all the way to the Quebec Court of Appeals. And the government got shut down in the application of trying to force companies with English-only names to adopt a French version. So this is huge. This is massive. So what does this mean? What is the implication for English businesses, or any business really, who wants to operate under an English name? So I don't care if your name is Jean-Pierre and you're in Trois-Rivières, or if your name is John Smith, operating in some English enclave in the province. Everybody who has a registered trademark in the land of Canada, in the CIPO, can operate that English name in the province of Quebec. Now, whether or not, and there's a journal that David has clipped out of the journal in order to say that, well, there may be nuances and they may legislate or make law ways in which we may have to add a descriptive term to the branding. For example, les cafés Second Cup, les cafés Starbucks. Maybe one day it'll be les électroménagers or les électroniques Best Buy. Whatever. So we're trying to, all these big box companies are trying to accommodate the realities of doing business in Quebec, but are fighting tooth and nail. So it's important for anyone who will be extremely reliant on their branding, who will have their names emblazoned on office buildings, and who will be conducting business with the public in Quebec, to make sure that they're protected. Now, I talked to you in the beginning that there's big changes coming in 2016. This is true. So Most people come and see me, say, okay, good, I'm in Canada, I want to protect my brand, but I'm going to the US immediately. Or I'm going to Europe immediately. What do I do? I'm trying to explain to you how it works. There's a class system in the US. There's a class system in Europe. What this means is that if I want to have wear hacks on t-shirts, so if I wanted to have one on Denis' t-shirt, if I wanted to have, what's your name? Tamil? Tamil. Nice to meet you, man. Nice to meet you. If I wanted to have something like wear hacks around your neck, or if I wanted to put it on your car, for example, would you be okay with that if I put it on your car? No? Even if we pay you a lot of money? Okay. So if I wanted to put wear hacks on his car, I'd have to apply for a different class. I'd have to get a different class so the t-shirts, the lanyards, the car, the water bottles, whatever, okay? So if every class I wanted to do in the US, I have to pay $250 plus make an application, plus I have to wait for it to be approved, plus it might be contested, da-da-da-da-da. So it can cost a lot of money, thousands and thousands of dollars. In Canada, if I wanted to have Denis' t-shirt and Tamil's car and what's your name? Yeah? Lisanne? Grisella. If I wanted to put it on her jacket, I would have to, in Canada, it's only one application. I just list what I want to get protected, and I pay one fee. There's one application. That's all changing in 2016. In 2016, Canada is looking to make a lot more money. CIPO is looking to make a lot more money. They're looking to the US and they're saying, oh my God, look how rich they are and look how poor we are. So you know what? We're going to do what they're doing. So Canada has said, we're going class system, similar to Europe. And this is what's changing. So we need to start looking at, anyone who has branding needs to start looking at doing this on a very short-term basis because it'll get a lot more expensive in 2016. So you'll be grandfathered in if we do the application now. In Europe, there's a Madrid protocol, which covers 28 countries in Europe. That's a whole different thing. So I often try to counsel clients about doing it in a way that streamlines or that harmonizes the procedure. US, Canada, Europe, depending on where you want to go.